one shouldn't be amazed in terms of how this country goes about its business. Things move, the goalposts get moved, other issues are introduced, and it
is a situation where that mechanism, which is problematic enough for allocating a right to reside for access to benefits, is being used and transplanted to decide a person's entitlement to stay in their home state, well, the place that they have made their home, rather. And that means that there's more dramatic consequences as a result of failing to exercise your right to reside. So if you're in and out of work, you suddenly lose that protection. And where are you in the withdrawal agreement if you cease to be exercising your right to reside for one reason or another? And there are some very good reasons. It's not benefit tourism is the tiny minority of the people who are out with the scope of right to reside at any one point. The people who are in and out of work, they're on short-term contracts, they may have hours that go up and down. There are people who take time out of work for care reasons, and that's the big group. Women in particular, who are disproportionately represented amongst that group, caring for children, caring for older relatives. And some of them are very long-term residents as well. And as I said, in the work that I've been doing with EU nationals in the context of claiming welfare benefits, this right to reside construct has excluded some very long-term residents, often disproportionately women, who may have been in the UK for decades, but if they have married a UK national rather than an EU national worker, then they're not exercising a right to reside. They haven't clocked up permanent residence. If they've then been a homemaker, or if they've been supporting their UK national self-employment, for their UK national spouse's self-employment, then they're not clocking up the 5 years necessary for a right to reside. And several decades down the line, their spouse gets ill or dies. They need some support, welfare support, and they're not entitled to it. As I say, the consequences will be more dramatic. It's not about not having welfare support, it's certainly not having an entitlement to stay in the UK, where they have been for many, many years. It affects children very disproportionately, because children have no means to independently, in their own right, exercise a right to reside under 2004-38. They only exist in that directive as migrant parasites. They only exist insofar as they're related to a parent who is exercising a right to reside. If they can't show evidence of that for one reason or another, or if their parent has employment, misfortunes or whatever, the child has no means to exercise that right to reside in their own right. If they're a child in care, how are they going to show that connection? If they're a child who's been removed from a parent because of a domestic abuse situation, how are they going to show what their parent is or was doing? And there was a case a couple of years ago now on the right to reside, again in a welfare benefit context, dealing with a 17-year-old child who was born in the UK. She was a Portuguese national, born in the UK, lived in the UK all of her life, was abandoned by her mother at the age of 16, who went to a third country. So there was no EU country for this child to go home to, in inverted commas. At the age of 17, claimed income support, was found not to have a right to reside. Now, under the withdrawal agreement, what that would mean is expected to leave the country that she had grown up in and never been anywhere else. And so the right to reside construct is totally impervious to questions of social integration, language, family, friends, and so on and so forth. It's all about showing that you're exercising the rights under 2004-38. And of course, under international human rights law, we don't expect children to have been working for 5 years, and we shouldn't. And yet somehow, because they haven't done that, they have no means of having a right to reside. So the withdrawal agreement is potentially very exclusionary and myopic in a way, in terms of the swathes of people who will fall through the gaps, because there's massive gaps. Care gaps, domestic abuse gaps, women who've had to be relocated, and as a consequence they've suffered a punctuated employment history, don't have the right to reside, the permanent right to reside of 5 years. Long-term residents, again, I've worked with women who've been in the UK for decades. There was a case in the UK tribunal of a woman who'd been in the UK for more than 33 years, but because she'd married a UK national, she hadn't accrued a right to reside in her own right. She had no right to reside. People with disabilities, more likely to be disproportionately affected. So there's a whole raft of gaps in there. There's another potentially significant gap in the withdrawal agreement, but it's difficult to know how to interpret this. So a group of carers who do have a right to reside under EU law are Texera carers or Tegera carers.
What kind of carers?
Tegera, I don't know how to pronounce the word, T-E-I-X-E-I-R-A. So it's a case in the CJEU which found that the child of an EU national worker or former EU national worker has a continued right to reside in the host state to continue their education. And for that to be a meaningful right, their primary carer has to have a right to reside. And they're Texera carers. And they appear to be included up to a point in the withdrawal agreement, but it says so long under Article 24.2, so long they'll continue to have the right to reside in the event that the EU migrant worker parent has left the state, has left the UK. And that's one scenario in which Texera rights kick in. But the other scenario is where the EU migrant worker parent ceases work. And that is not explicitly covered in Article 24.2. And I'm not sure why 24.2 exists, if other than to create that exclusion. In theory, because the case law of the CJEU is meant to continue to apply, in theory, because the relevant regulation is meant to continue to apply, all Texera carers should be covered. Mm-hmm. But this particular provision seems to suggest it's only some who will be favoured and some who won't. And the ones where the EU migrant worker parent has ceased work are not explicitly covered in this provision, which could be problematic. Yeah.
So do you think if there is a deal done, then there's either going to be supplementary advice covering these areas, or we're back in the courts? Well, it'd be straightforward, not back in the courts, because it seems it's deliberately not mentioned because there is no right. Is that what you think will happen if there was a deal done? In those areas that you've outlined, and some of these gaps, these areas there's no explicit provision. It's either a free-for-all or open to interpretation by.
Well, it seems to be then just down to domestic preference, really. And so, I mean, we've got the UK proposals, which would appear, on the face of it, to cover a lot of these people, because they just ask for residence. They don't ask for evidence that someone's been exercising a right to reside. Now, there are a number of problems with this. First of all, if you're relying just on domestic preference, then that's obviously subject to the whim of the executive or whoever's in charge of writing the regulations at the time. It's amendable. It's also not enforceable at an EU level. The EU's just cut these people loose, effectively, according to this withdrawal agreement. And it means that there'll be a sort of a patchwork of rights across different member states, according to what other member states choose to do about the UK nationals in these situations there. And another problem with the UK proposals is, well, first of all, the hard deadline that appears to be suggested, which would mean that while a lot of these people would have an underlying right to settled status, they may not in effect realise that right because they missed the deadline, or because they're in a vulnerable situation and they don't know that the scheme exists, they don't know how to apply, they don't have the support to apply for it. Children in care, who's going to take responsibility for making sure they get registered?
Christopher, Sunder, do you want to add to that, or do you want to highlight something a bit further? And I suppose I want to thank you, Christopher, for the additional information and the flow charts of the complexities of what goes through. So we'll record that formally into our evidence.
So just to build on what Professor O'Brien has been saying, so 3.5 to 4 million people, maybe a third of them in London, in the UK, and then the European nationals, the British nationals out there in the EU. The withdrawal agreement, if we get the deal, will be the withdrawal agreement. There will then be some oversight rights of the European Court of Justice for 8 years, beyond that, and so on. And then you have national policy. And in this respect, national policy based on what the UK government is saying is offering reassuring language, and therefore we've got to look at the delivery, and there might be other challenges for people in other countries as to whether all the gaps are filled. So the question in terms of the UK policy, so the biggest thing that the UK policy does on a voluntary basis, not in the withdrawal agreement, is it doesn't now look for the comprehensive sickness insurance. And when we've been seeing, and we're still getting refusals, we've been seeing a quarter of cases refused, and there's a very good case to say, shouldn't we have a moratorium on refusals now in this period, because it must be quite worrying to be getting refusals. We're looking for a 99%, 100% acceptance rate very soon. Should we still have had a 25% refusal rate? Because there's very low trust. So there's a government saying very reassuring things, we want to cover everybody, and very low trust in the client group because of the politics of this, so those refusals. Now, what is a reasonable ground to refuse? The government has a couple that I think would be broadly accepted. One is serious criminality above the criminal threshold that already applies to EU citizens. That seems fair. There may be people with some criminal history that isn't at that level at all, who don't know that it's not at that level, don't apply and so on. But the serious criminality, identity fraud, not being who you say, and not being resident here at all. Those are the reasonable grounds of refusal. The UK government is saying that residence is what we're looking for, and therefore that higher threshold is not what we're looking for. So what we now need to look at is that what gets applied? Is that what people know will be applied? And do the people who could apply under that basis then apply? Or does something else happen? Do you get exploited by somebody else? Do you pay many thousands of pounds to somebody else for advice? You know, if you've been working cash in hand because you assume you'll be refused. What's our communications and advice like? Thinking about this big group of 3-4 million people, it's quite probable that the government, employers, other people, the computer systems that have been set up, assuming they work well, it's quite probable there are going to be multiple routes to about 2 million of these people, and that we'll keep finding the same 2 million people. You know, if you've been in work, you've got good tax records, you know, you've worked in the public sector and so on, we'll keep finding 2/3 of the group very, very easily. And they may or may not often be the people who it's easiest to communicate with about this is about you. So the groups to worry about are the people who will just have less footprint on the systems, might not have met the old tests of the directive, but would, if they knew it, meet the test of you're resident, you're really who you say you are, get into the system. So the bar, in theory, is set very low for pre-settled status. I might have been here 20 years and have very little evidence of it, but you know I'm here. Then I'll get pre-settled status. I'll get the right to build up 5 years. If we have a lot of people in that box who've been here a long time, then we'll have a very big problem in 5 years' time. And we'll have to keep our eye on that. And there'll be other people, you know, if you've been here more than 20 years, you know, there might be 300,000 people like that. You might think this is for the people who arrived in the last 10 years. You might not know that if you're a child and so on. So there might be, you know, 1 million people who, unless we get good advice to them, won't know this is for them. And there might be other people, for example, who think, I've got a very patchy employment record, you know, my employer hasn't been paying any tax, I better not apply. So I think there's a very big group that we need to worry about whether they'll get through the system. And then there's another issue, which is, will the refusal rate be below 1%? Because if it isn't below 1%, and also what is the pace of applications that we're expecting? We've never seen 4 million people apply for something in a 2.5 year period, so we don't know whether we're ahead, behind. If we got 95% of this right by the middle of 2021, that, you know, I think we'd all be reasonably relieved to find that we've done that. That will take a lot of investment, a lot of resource. That would mean that 200,000 people didn't have the status that they would have been entitled to, and therefore from the start we need a sense that we're going to think about, if you were eligible. At the moment the thing says, did you have a good reason not to apply? I'm not sure you need a particularly good reason not to apply. You need an eligibility for the scheme. There's bound to be a problem at the end of 100,000, 150,000, 200,000 people if 95% of this went well, and we ought to have a sensible policy at that stage. If that problem is 400,000, 500,000, 600,000, then we've got a much bigger problem.
Yeah, I would say that the Home Office's message and the communication is that this is quite simple, and residence and identity and undergo a criminality check is, you know, the steps you need to do to achieve your residence. But there's some devil in the detail. They published the suitability requirements just over a week ago, and that allows the Home Office, if they so choose to do so, to assess under current EU law and the EEA regulations on whether someone is working or exercising treaty rights or not. So it's not just purely residence. So what the suitability guidance tells us is that if someone applies and they're not in work or they've never worked at all, and they provide the evidence of residence for 5 years, and that application goes into the settled status team, that settled status team will then review the application and see that that person has not exercised any treaty rights or hasn't worked at all for 5 years. Then they can then pause the settled status application and then consult in consultation with a senior caseworker or the European Migration Policy Team. They then can decide whether enforcement is required on the current EEA regs on the non-exercise of treaty rights. So what will happen is someone applies because they're not working. The general caseworking level sees that they're not working, asks the senior caseworker, what do we do in this scenario? They, in consultation with the other team, decide, well, they've never worked. Maybe then we need to consider whether removal should be instigated under the current EEA regs. So the settled status will pause, the EEA regs will kick in, and they may consider issuing a removal decision because of non-exercise of treaty rights, and then the settled status application will restart, and then that will be refused because a removal decision is now valid and active before the deadline, before the decision of the settled status is made, and then the applicant then will receive a refusal of a settled status application and also a removal decision. And then they'll have to then challenge a removal decision before then they can challenge a settled status application. So residence is the main requirement, but the Home Office have the power to choose whether to instigate removal of non-exercise of treaty rights or misuse of rights still. But what we don't know is who are they going to exercise that power against? You know, is it going to be a 25-year-old Eastern European man who's never worked, or is it going to be a single mother who's had to stop working to look after her 2 children? You know, if it's applied to everyone equally, then fair enough. EU law still exists until the end of the transition period. The Home Office have the right to exercise that power. If they apply it indiscriminately or target individual groups, which they have done in the past, then we've got a major problem on our hands.
What we would like then is some clear language and some policy to go with it about why and when will that be applied exceptionally, as opposed to in a broader sense, because there is a clash between doing that and saying the test is identity, residence, and not having serious criminality. If you applying that, then you should not be doing this, and there are exceptional public danger, criminality reasons to do it.
I mean, the Home Office published a caseworker guidance at the caseworker level, but we never see the senior caseworker guidance. We never see that technical decision making on those detailed cases. And maybe if that's published, then we can have a clear, transparent idea of what they intend to do when those complex cases hits them. And through the European Commission, we've asked for that guidance. It's never been supplied, only the caseworker level guidance, which only covers the straightforward cases, which will be the majority of those who are in work and can work. And then we also don't have answers about whether the Home Office will disclose information to other government departments or other third parties. They say they can when the settled status email is issued to people during the testing phase. They receive an email saying you've got settled status, this is your rights, this is how it will work, and also we may share data with other third parties. So my worry as well in another group is if someone who's made a settled status application on the basis that they're employed and they've provided their pay slips and P60s and everything in the application indicates that they're employment, and then the application checks HMRC and HMRC comes back and says we've got no records of this guy being in existence because maybe their employer is not paying taxes and taking advantage of the employee, will the Home Office then, when they discover the inconsistent data from HMRC, then disclose that information to HMRC that this is a person who may not be working or their employer has not paid any taxes on their behalf? So we don't know how data is going to be shared with other government departments or even third parties.
Well, thank you for that. In terms of setting the scene and the complexity of the issues that need to be dealt with or thought about, are there any questions before we move on to the next section on this part of the questioning? Because I think I've covered all my areas. And
I just wanted to pick up on the children again, just to clarify. So if you're saying they've got to be working for 5 years, but anyone then, if you assume people are at school until they're 18, then no one will have worked for 5 years until they're about 23, 24 maybe. So we're talking about a big chunk of young people who could have grown up in this country and suddenly find that actually they don't have settled status here, and does that mean that they would potentially just have to leave? And do we, in which case, have a sense of how many of those young people there are?
According to the withdrawal agreement, yes, there would be a large number of children who would not have an entitlement to stay in the UK, either because they themselves have not been exercising a right to reside under 2004/38, like working, or because their parents haven't been. I mean, their parent may have had a Tajera carer parent, but Tajera rights don't accrue. They don't clock up the 5 years for permanent residence, and when they would be assessed as to whether or not they fall within the scope of the withdrawal agreement, will be found not to be exercising a right in accordance with the directive, and therefore not have an entitlement to stay. Under the UK proposals, it would be different because of the concern about residence rather than exercising a right to reside. So, if the UK proposals survive intact, and all that's asked is have you been resident for 5 years, then a lot of children would be, in theory, in the clear. Of course, they could also potentially fall foul of this. They've not actually been exercising a right to reside rule. So there's this inherent contradiction in the UK proposals saying we're not looking for you to have exercised a right to reside, but if you're not exercising your right to reside, we might remove you.
I'm not sure that is whether that's a contradiction. Under the UK policy, the answer is they're all supposed to be covered. Either you're eligible if you're attached to a person who's eligible for settled status. If you're not attached to a person who's eligible for settled status, but you're a resident in this country, you are eligible, and so on. And so, there are a range of risks, and that if you're attached to a person who might be removed for some other reason, that's it. So I would say it's a different level of risk once we're in the UK policy. What's it meant to do? It's meant to cover them all. Who might it not cover? 300,000 of these children are born in Britain, and there might be a belief that they are already covered because they were born in Britain, but it depends what year you were born, what you're registered, are your citizens. So there might be parents with British-born children, the rules have changed at different times, and they might not register the right children. What we do, but there's no doubt under the UK policy that it's supposed to cover all the groups, and then it's making specific, children in care and the responsibility of councils and so on. Whether or not people know what they're meant to do is probably a bigger thing than are they eligible at all.
It's not so much a deliberate. It's a gap that that exists, that is a risk, but it's not deliberately trying to get it.
The UK policy fills a gap that the withdrawal agreement would not. But then this therefore is the UK government and the UK courts under the domestic law when it's passed, not the EU treaty, because it's up to the nation state to augment EU law and directives, and that's what Britain.
Okay, now I'm finding all this really confusing and complicated, and I have a lot of friends in this country who are EU citizens, who have children born and brought up in this country, and I'm hearing from constituents and friends, their concerns, and people are worried about falling between these gaps, and I'm just wondering what information is out there to help people to navigate their way through all of this. Is there information out there? And if there isn't, who do you think should be producing it?
So the GLA have their portal on citizens' rights. So we've got a guide on there and some question scenarios on there and referrals to any organisations that can give advice. And so that's fairly new. And then the European Commission Representation Office in London has published a Q&A document on the process and settled status and scenario questions on a range of topics like I'm European, but my Brazilian wife is here. Can she stay with me, for example? So there's that information there, and they're also providing information services in partnership with a range of lawyers. So they provide public seminar sessions, which we've participated in, and open Q&A sessions with citizens as well. Some of those have been live streamed. And what they intend to do beyond January onwards is to try and get a more centralised information portal. So similar to the GLA one, but on a national scale, which will have the same information available and recommendations on who to seek advice from not-for-profit organisations, but also to try and centralise these information sessions, because a whole range of organisations are providing them. So if we're going to have some central database that people can log in, put their postcode in, and find out where the next information session is, that they can attend for free. So they're working on trying to build that up a bit more. With
The
European Commission representation, and our firm is contracted with them at least up until March next year to provide that. The Law Centres Network are providing similar things in partnership with the European Commission. They focus on charities and voluntary groups who want to set up these information sessions. We work in partnership with the Commission with embassies that want to set up these sessions. So the embassies have set up over 70 of these sessions, and we've participated in them for all across the UK, including Northern Ireland.
So one of the gaps that may appear in terms of that provision of information, if things ever do become clearer, is maybe employers. So we need to get to employers to make them to carry out some responsibilities for their employees and be able to get not only brief themselves up on good advice, but also the individuals. So that could be one of the things that we suggest to the Mayor, that he ought to concentrate in London, that we get this out to employers as far and wide as possible.
Yeah.
Sorry, Caroline, I just want to...
Yes, sorry.
Yeah, I was going to say there's been employers that attend these sessions, and they have also then had been encouraged to hold their own sessions as well. So they've done similar sessions for their employees, and that's a good way of doing that. It's also good PR for the employers. They can tell their staff, we want to look after you, we want you to stay. And frankly, it's quite cost effective for them, rather than they lose staff and have to hire again and retrain staff again.
But again, that's talking about bigger employers rather than the smaller.
I think even smaller employers. I mean, the cost of maybe having a lawyer present if they don't want to do it themselves, but is going to be smaller cost than compared to having to recruit and restaff and retrain people as well. But the Home Office are also preparing lots of communication materials as well. So they've got an employers toolkit, which is available publicly, and they're reformatting that for charities and not-for-profits, so they can have something to distribute as well.
Do you know when that's...
the employers toolkit's available. I'm not sure of the availability date for the repackaged one for charities and advisors. What the Home Office intend to do the Home Office have worked up a communications model. And so they're providing all these pamphlets, but they're also going to then, the next stage of that is to then communicate this to everyone that gives advice to EU citizens, to make themselves known to the Home Office, so the Home Office can have a map of who gives advice, the extent of the advice, and allow those organisations then to order all of these pamphlets and leaflets and information, so they can then be distributed onto the advice sector. It still falls short of what I think the Home Office should do, because their campaign model is not really going to reach all of the vulnerable groups, those with dependency needs, those who are in close-knit communities, and they really need to start thinking about the more traditional advertising models like TV and radio and so on, to really access people where they engage with communications, because at the moment their communications are mainly online, putting adverts in Spotify, and frankly that might capture a few people, but it's not really going to capture all of the people that are going to be vulnerable in this process.
There is going to be a significant amount of communication. There is a plan for a significant amount of communication, and there are a significant number of stakeholders that want to be involved in that. Employers have been very keen to be seen to be involved. They think it's ethical. They have an interest in doing it. The government itself will do it. I think there are a couple of complications about getting this right. Firstly, however much you do, it needs to be systemic, it needs to be sustained, and maybe it will never be enough. But actually, a lot of people are going to step up and in a way reach the 2/3 of the people that we will find relatively easy to reach, I think. So that is the first challenge, that a lot of the energy might be attached at the relatively above the line groups, and therefore just making sure there's energy that's going to the harder groups. But embassies will be doing things, employers will be doing things, and so on. But it might be the sort of higher end of the labour market, and the firms who feel they have a reputational advantage, and we might particularly want the lower end of the labour market to be as engaged. So that's, I mean, there will be things in different languages through embassies and so on. There's some money being spent, but if you look at it, you would say that doesn't sound very much. If there's £9 million going to NGOs and civic groups to reach harder to reach audiences, and that you've got a list of sort of 50 different harder to reach audiences, then that's the challenge. So while there'll be a lot of communication in general, I think working out how does it get to the more vulnerable groups is there. The other thing is, I think the message really needs to be very, very simple, and that what we really need to have a strategy here is vigilance without alarmism. The simple message is, here's the information, everybody should be eligible, you're eligible, here's what you do, here's what you show, you all need to apply. If you've got permanent status already, you need to swap it over, it doesn't cost you anything. There's a level of detail, but it's like engage with the system, which when people do engage with it, if it goes well, they might find it surprisingly less complicated than we're expecting a Home Office system to be, because it is. And then this other set of issues of we're all keeping an eye on the policy gaps, etc., we need to keep that away. We can't have a complacent message, you'll all be fine. We don't know that. But we can't have there are lots of ways you might worry about it, because there's very low trust, there's very high concern, and if they roll out the system and it doesn't fall over, then most people should find that they're able to engage with the system, say who they are, and get a decision. And that we should worry a lot about the reach out there, but we should separate our policy worries about, are we going to reach the last 500,000 people from we're all very worried about trust in the Home Office. That's already there. So I think the GLA needs to think as well about just communicating the very simple, here's the information, here's what you do, here's how long you've got.
I'm sorry, because I haven't
We'll
looked.
move off on that. So has there been any conversation, it's not perfect, that the electoral registration system will record some EU nationals for the purpose of voting, so they can vote in regional and local government, local elections. Has anyone talked about using that list to contact people with the right message, of course? Has no one raised that?
No,
Okay.
no.
Well, we might try and look at that. It's not perfect, won't reach everybody, but it will reach, I mean, it's particularly imperfect in transient areas, but where it's more settled, then people will be on there. I'm sorry, Karen.
Sorry, just going back to this information. So the GLA portal, is that easy to use? Is that does that fit the bill in terms of getting? I'm sorry, I haven't looked at it, but
it's still not as simple as we'd want it to be. I think the Home Office publications are, I mean, from a lawyer's perspective, I think they're a bit too simple, but I'm a lawyer and I know the detail in all this. But they're probably simple enough for those that we're worried about to understand. I mean, for example, I attend these information sessions and give these seminars out, and I'm still surprised, even at, as near as last week, that some people still have that disconnect between Brexit and that they have to actually secure their residence in the future to continue residing here. So there's even that level of basic understanding that you need to reach. And maybe it's and Home Office materials might be useful, and maybe it's an idea that maybe we can have them available to social services, to hospitals and emergency wards, anyone that may come into contact with those that are maybe not employed, and so anyone that touches anyone in the public sector that finds an EU citizen, they can say, well, oh, you're an EU citizen, here's a leaflet, it's got nothing to do with what you're coming to see us about, but read this, it may be relevant to you. And maybe it's getting that materials out to people in all of those places might be just an idea.
That's certainly something we can presumably talk to the mayor about. Moving on, looking at the sort of future systems, the government's been very clear that after the transition period has ended, there'll be a new immigration system, and that the freedom of movement between the UK and the EU will come to an end. So, first of all, to Charlotte and Christopher, sort of after leaving the EU, what would the UK's new immigration system look like, and what would it mean for EU nationals wanting to come to the UK to work?
I think, in a word, there's a risk that it will look messy. That bearing in mind that we'll still have people, EU nationals in the UK, subject to a new old regime, and then new arrivals subject to a new regime. We'll have multiple parallel immigration regimes with different entitlements running simultaneously, with different evidential requirements, with different procedures, all being processed by the same overstretched department in fairly short turnaround times, with different enforcement procedures.
Overstretched department.
Yes.
Just thinking back a step to the people we were talking about before, the current people here. There was a sense that it was going to be quite straightforward to deal with the majority, and there was just going to be the 200,000 or so people who it would be hard to find. Do we think there is capacity to process the people who are here before we even think about the new system? Or do we think those workers are going to be very, very stretched in order to deal with the...
I think what the Home Office intend to do, making the application online and fairly automated with residence checks with HMRC and DWP and having identity checks with mobile apps, is that they really intend the system to be as automated as possible without any human interaction for those straightforward cases that tick all the boxes and have all the evidence. So hopefully the system will then process those without much hassle, and they will then start achieving high workflows. But then the problem is going to arise when people need to scan and upload additional residence evidence, or they don't have a national ID document to confirm they're a European citizen, or they have criminal offences. And then once casework, when there needs to be then human interaction, casework involvement in the cases, then things slow down substantially at the Home Office, as they do now.
I think you could estimate that group might be 10%, it might be 30%. You know, it might be the biggest thing that will make a difference to it going right or going wrong is the recruitment and the training of the staff who will be doing the human bit. It would be brilliant if the computers do 2 million of them without needing a lot of things. But the human bit is very, very important. They say they're aware of that, but I think this is exactly the sort of National Audit Office and Immigration Inspector and Parliamentary Scrutiny and GLA Scrutiny kind of question of, have we got the right people? When they give us they should be very transparent about the data, how many people applied, what are the acceptance rates, what are the timescales. If they're clear, I don't think they've said yet, but if they're clear, you know, we're expecting a 10-day turnaround or whatever it is, and they're delivering it, they're not delivering it, we should know a lot 2 quarters in. About because there should be quite a rush about the system appears to be adequate to the first few 100,000 it got, or the system is already looking not really up to the job.
I mean, it's worth noting that according to the technical note issued around about this time last year, that the Home Office was promising a greater degree of human interaction on those cases that required it than currently happens at the moment. So there would be more of exercising discretion and giving claimants the benefit of the doubt, and involving an extra layer of dialogue by getting back in touch with claimants if there is a problem with some of the evidence and advising them what to do instead. And this is stuff that doesn't happen now. When you're dealing with potentially a bigger caseload in a short period of time, there is a risk that those promises aren't terribly plausible, especially bearing in mind the evidence that was given by the former head of immigration enforcement to the Home Affairs Select Committee last year, that the department was like an ineffective sausage factory with low-grade staff. Unless there's a very significant planned improvement in how cases are processed when that human interaction is involved, then there's a very significant risk that things are going to go wrong and not get the attention that they require.
But the plan where the language is reassuring is that the plan is to have specific capacity to do that, and there's a lot of warm words, so it's called a customer resolution centre. There's a lot of language that says this is here to get you through. And in some ways, if you want to be cynical about it, you'd say it's almost like you're creating teams to say, don't act in the ways we always act. Do the opposite. That's the policy. You're the team to approve people. You're the team to not refuse it. You're the team to get back to people and say that. And there ought to be an opportunity then to say, well, if that worked, is there a culture change opportunity for the future system? But the first point is there specific dedicated capacity, and is it doing what we were told, which is it's there to say yes to people and to check what else you need to say yes.
And did you say sort of 2 quarters in to this, we'd start to get a sense
So
of...
we get data straight away,
Yes.
but I think having indicators so we know what we expect. Someone says, well, it's a unique situation. Who knows how big the rush should be? Maybe we're behind for good reasons. Let's set some indicators, especially then when you get to the end of the 2.5 year period. You know, if we're not at 75% of cases through and processed with 6 months to go, we should already have said, well, it needs to be kicked on a year. At that point, we don't want to say that at the start. We want to have a deadline where people apply so that they apply. But we should already know. We shouldn't be saying, oh, well, there's a rush at the start. We're hoping for an even bigger rush at the end. You're right, 1.5 million cases missing doesn't sound very good. We should have a reasonable sense of what would on course look like, and is there already a sense that the remedies for not being on course are you extend the timeline, you spend more money, and you invest in the system?
There's sort of two separate variables here. There's the processing time, which, as you say, we can get from the data, but then there's the question of application flow, which is very difficult to predict. I mean, to what degree are people going to think, well, I've got 2 years, I don't actually need to apply it straight away?
I mean, the Home Office are going to publish application processing times online, so we'll have that data. But what we should encourage the Home Office to do is actually to publish engagement with that, how many people have applied, so everyone, so it's quite transparent to everyone where we are at that stage, because you know, with 6 months to go and only 75% of people have applied, there needs to be a considerable amount of planning to stop 25 or 30% going unlawfully resident at the end of the deadline. And so that will need to be continually assessed. I'm sure the Home Office will assess it, but I think it's wise for that data to be also
Does the
publicly
2 years
available.
start on the 29th of March, or has it started?
So the transition period ends on the 31st December 2020. Then we've got that 6 month grace period for people to apply.
The transition period ends
On the 31st of December 2020, and then
If there is a transition
assuming there is a transition period, and then
so in the event of a no
in the
deal,
event of the no deal, there isn't a transition period. And there is a what period of time are they aiming to?
It's the 1st of July 2021 is the date.
Yeah.
So this is widely misunderstood, I think, that the transition period and the position period to apply to this, they happen to be running over the same 2 years. They're completely different.
Yes.
So in a no-deal scenario, the government doesn't want to admit this, even in the deal scenario. In the no-deal scenario, the government will not be able to have immigration controls until the 1st of July 2021. And if it tries to have them, or it doesn't admit this, it will create an enormous catastrophe with lawyers, landlords, discrimination, and so on. So at some point in a no-deal scenario, they have to show how they're doing it, what they're doing, and they have to say people are continuing to come in on this basis because people who are here now have got till July the 1st, 2021 to apply for this scheme, and they don't need to have done anything. So I cannot tell the difference between somebody who's been here from Italy and Poland for 5 years and somebody who arrives tomorrow, because the person who's been here 5 years doesn't need to show me anything. So that's true deal or no deal. It's also the case if you then have a transition period, you've got another reason why everything was carrying on the same until December 2020. So it kind of covers up that you've got to do that. The immigration minister sort of fell over at the Home Affairs Select Committee because she didn't really want to admit that in the deal or the no deal scenario. They want to say, well, free movement will have ended on Brexit Day, of course. And then what else will you have done until the 1st July 2021? You really can't do anything else. So the grown-up thing is just to say, it will take us time to design our system well. We've got this amount of time. We won't be telling you till this white paper what it is, but let's not create an expectation of changes on Brexit Day when you're getting changes in July 2021, and that would calm down the mood, I think, for EU nationals themselves, for employers. You know, is there a cliff edge? In all of these scenarios, you aren't able to have new immigration policies until July 2021.
I mean, just thinking back to the issue about giving information to employers to give to their employees, one of the problems we have, particularly if there is a no-deal scenario, is it's not at all clear what the advice to employers is meant to be. In terms of, and if we look at the exchange between Caroline Noakes and Yvette Cooper, there were a number of contradictions about what employers are supposed to be doing in terms of checking whether someone has an entitlement to be in the country based on settled status, or if they've been resident in the country for 5 years, or if they've only just arrived. But the people who are entitled to equal treatment should not be subjected to significant extra checks. But how do you know if someone's entitled to equal treatment unless you do those significant extra checks? And so there is and I think one of the things that Caroline suggested was that that they wouldn't be expecting the system to be overly rigorously enforced. And you think, well, what does that mean? Yes. Yeah. But at the same time saying, but we expect employees to do adequate checks. So it's, I think that the message would be incredibly mixed, and employers wouldn't really know what they were supposed to be doing in terms of checking whether or not people had settled status, or they might not have the settled status certificate, but they may have applied for it but not yet received it, and they have no evidence of that. That you know they wouldn't be able to produce the document, the single document that should settle the question.
So just to be absolutely clear, if sort of post 29th of March, deal or no deal, people will still be able to come here and they will have until it looks like the 1st of July 2021 in a no deal situation to sort out their...
The government then has to pass a law to make that the case. The only sensible policy that fits with the government settled status scheme is to say that what we're asking employers to do is look at a European passport or an identity card as they do now. That's what we can do, and that's whether you've been here 20 years or that's whether you're coming in, and they'd have to make provision for that. If they pass the withdrawal agreement bill, the withdrawal agreement bill will make provision for that. Yeah. The rules will still be the same. Yeah. If they haven't done that, they will have to make those the new rules for the first 2.5 years so that their scheme works. Otherwise, their scheme will fall over.
Okay, and then finally, EU nationals with settled status, will they be affected in any way by the new immigration system? Or does if someone is an EU national with settled status now, is there anything that they need to be worried about in relation to the new regime?
The only thing sorry.
I was just going to say that according to the current proposals, once they've got settled status, that's it. Yeah, unless they are out of the country for a sufficient period of time to lose that settled status. But of course, subject to the degree to which it's mirrored in the withdrawal agreement, there would not be kind of supranational enforcement. So we can't necessarily... There wouldn't be a legal guarantee that the law wouldn't change at some point. But that's not the intention at the moment.
It's more generous than current forms of ILR and permanent residence, because you can go for a complete period of up to 5 years without affecting your status. If you go for a complete period that's over 5 years, you would then become a new person. But for everybody else now, that would have been 2 years. So that's how you then end up back in the what do I need to apply for.
Yeah. So I would say the withdrawal agreement provides that protection that the settled status can't be taken away unless it's for a very specific reason. So there's that absence, and also criminal offences. If there's a serious criminal offence, then they could lose settled status at that point.
Well, the withdrawal agreement protects permanent residence.
Permanent, yeah. Which
could be a different thing. You wouldn't necessarily be entitled, according to EU law, to permanent residence, even if you got settled status.
So I mean, if the way I answer it, settled status granted under the draft withdrawal agreement, if someone then commits an offence post 31st December 2020, so after the end of the transition period, that offence can be assessed under UK immigration law. And so if it's that means if someone commits an offence which then attracts an imprisonment of 12 months or more, then they move into the automatic removal process. And so then settled status is at risk then at that point.
Yeah, unless you become a citizen. Yeah. If you become a citizen, you'd then be in the other.
Thank you.
Assembly Member PG.
You've already started to touch on some of my areas of questions. This is so complicated. You're all of you really deeply involved and have a huge understanding of all of this. But my question's around no deal, and so you've already started to touch on them. But simply, maybe Charlotte, in the event of actually a no deal, how will the status of EU nationals living in the UK be affected? Just in simple terms.
Well, if there is no deal, then there would not be an EU level or supranational protection of the status of those EU nationals in the UK, or the UK nationals that live in there would be, potentially depending on what domestic law is, there may be domestic provision for them. And it's not totally clear. I mean, the UK proposals, we're told, are not dependent on there being a deal, and yet a lot of the detail of the statement of intent appears to presume there's going to be a deal, and so there is a risk that those UK proposals will change, will shift, or be used as leverage to try and get some sort of reciprocal guarantee, even if it's bilateral guarantees from other member states. There is the possibility of attempting to ring fence the citizens' rights provisions in the deal if it looks like the overall document, the overall deal is a non-starter. Then it might be possible to harvest out the citizens' rights provisions because they are the provisions which receive amongst the quickest degree of agreement. It's accepted that not having any kind of provision, just having a status cliff edge, would be like a human catastrophe for a lot of people. There are some legal questions over the possibility of doing that, but it seems entirely plausible that would be. I think it would be advisable rather than having no deal entirely.
When we've talked about talked to the Home Office in a no deal scenario, they've never really answered the question directly, but they've always said that their intention is for the settled status process to be available whatever the outcome of the negotiations are. So they've invested a lot of time and money building this toy, and they're going to want to use it essentially. So in a no deal scenario, if I can guess how it might work, then is they still have to implement the European Union Withdrawal Act, which brings the current European regulations into domestic law. The European regulations is the thing that brought the Citizens' Rights Directive into UK law. Once that's there, that gives them the legal coverage to then say, look, this is now the transition period for people to apply for settled status. So in a no-deal scenario, you'll still have to apply for settled status. This is the deadline to apply for settled status. And so you've still got time to do it, and you've got the legal coverage to do it. My worry in that scenario, though, is that although they'll be able to protect residents' rights, all the associated rights that come with residents might be affected.
So can you give me some examples what you mean by that?
Family reunification, so family members who are not yet here who can't enter the UK.
You lose that,
social security rights and pension rights as well. So whether you can, you retain your pension when you go back to Portugal, and that pension continues to be uprated, that won't be available, in a no-deal scenario. I think the biggest one is family reunification rights. That will be the biggest obstacle, and I think that's where the Home Office then might look at the process in a no-deal scenario and say, you know what, we were forced to protect these issues under the negotiations, but now we've got the unilateral power to say what we really want to do. And it could be other scenarios as well, like Surinder Singh scenarios as British nationals who lived abroad and came back into the UK, and they're able to bring their family over under European law.
I think in a no-deal scenario, it's really, really important to ring-fence the citizens' deal as a ring-fence deal, and it's difficult to see why there would be an objection on any side for doing that. The UK government sounds quite open to it, but I think the Mayor, the Assembly, Londoners should be looking for both sides to say that. And the reason it works, it's very important for the Brits in Europe because 28 sets of bilateral arrangements. I mean, so much will get lost.
Yes.
In a way, if the UK government then did what it should say, there would be some risks and losses, especially of the appeal rights. But if they implemented the same scheme, there wouldn't be. But what the message would be, look, people can argue about the market access and the 39 billion quid, but that's enough to argue about, and that no one is in particularly in a worse position in the poker game, other than that they're holding 4.5 million people to ransom, to sort of saying, we'll put that through, and there's no legal barrier to doing that, and that's especially important to the. But if you don't do that, I think the political risks starting to unpick the deal, as opposed to saying, well, we should do what we said, are quite high, and there should be pressure to say introduce it as it was. You lose the legal oversight from the EU end. So, for example, the European Commission is in charge of overseeing it, and we're creating a new domestic thing, an independent monitoring authority that only comes into place in 2021. Well, we need that quicker, and so on. So there are detailed things like that. I think the only sort of, I suppose, politically tempting thing for UK government of saying we'll do the same thing, but here's a tweak, would be they might decide that, you know, could they have a tougher criminal threshold from the start, because the criminal thresholds for other forms of non-EU migration are tougher than the EU ones, and at some point they'll make that transition in the change. They might change that. I think there should be political pressure to say, if you're sticking to what you said, stick what you said, but it's so much better to do it on an EU-wide basis than to do it as a domestic law.
And do you think, if there is a no deal, will it also affect EU nationals' ability to access things like public services, rights to work, rights to remain in the UK? Would it effectively create a sort of different class of citizen?
Where it will do that is because of confusion and miscommunication,
Right.
and people accidentally breaking the law or deliberately breaking the law because people have heard about a no-deal Brexit, and they're landlords, and they therefore don't know if they should rent this house to somebody who's Italian, and so on. And so I think there's significant risks of people not understanding. Now, the government also has to pass a law, so what it wants to be the law is the law. And, you know, there'll be a lot of laws to pass in a no-deal scenario. But so the big risk is around the communication that nothing's changed. But you've got some hate crime risks there. But you've also just got some confusion risks for employers and landlords that they're not supposed to be doing that now. That shouldn't be. If the government's doing what it's meant to do, there are no risks to your status if they've passed this deal or got it through. But the people might not understand that.
So do you think, as say, those EU citizens will almost be seen as a different class, effectively, because they're just in a different space at that time?
I mean, I think it's worth bearing in mind that already we have a system where EU nationals do have to go through different sorts of checks to UK nationals for various kinds of services, and to show their entitlement to equal treatment, to show they're exercising a treaty right. And those kinds of hurdles do create different administrative experiences and different risks of administrative injustice. And my concern is that will be just on a different order of magnitude. Particularly if we're in a no-deal scenario and the government is maintaining that employers should be differentiating between new arrivals and people subject to the old regime, in inverted commas, those entitled to settled status. The kind of bureaucratic hurdles that people have to go through, the kinds of checks that they'll have to go through, it's difficult to know what they're going to look like, especially if their employers are being told, on the one hand, actually you shouldn't be discriminating, you shouldn't be treating this group of people differently, but you should be treating this group of people differently. And how do you find out which one they fall into?
The additional checks and pressures on employers, as you say, and others. And
a deal will depend upon what status people are deemed to have, A, if they are new arrivals, and B, if they're people who are already here but they haven't got settled status for one reason or another, or if they're on the pathway to settled status, and what it is they're supposed to do to maintain entitlement to reside in order to get settled status. So if someone hasn't registered in time, I mean, we were just discussing before, will that mean that they're effectively treated as an undocumented immigrant subject to the kinds of legislation that apply to illegal immigrants, in inverted commas? Will they be subject to the hostile environment? Will they suddenly find that every time they bump into other bits of law, they're committing criminal offences just because they haven't registered? There's a number of risks, I think, of administrative injustice, a number of risks of administrative discrimination, some of it inadvertent, some of it out of confusion, some of it potentially because the system almost requires it.
Are you concerned at all? We've seen, in recent times, the Windrush scandal, hostile environment checks destroying lives of people in this country legally. Are you worried that the government is in such chaos on this, the whole approach risks that there could be a repeat for EU citizens being treated in the same way?
I am concerned, yes, especially on the point of people who don't register in time, or can't produce the evidence of their residence for one reason or another. They haven't got the footprint. An awful lot seems to be in the pilot scheme based on having an ENO. What are the people who haven't got a national insurance number for one reason or another? The people who've been trafficked, who've been doing unpaid care work, who've been relocated due to domestic abuse, children, so on and so forth. There is a significant risk of people not meeting that deadline or not having the evidence and not having the document that shows their entitlement when push comes to shove, when we reach Brexit point, end of transition point.
It feels like very vulnerable people.
Yes, and including old age people in particular as well. I know that Age Concern are very concerned about the effect on older vulnerable people, particularly isolated people, non-internet using people. And worth noting, of course, that has a disproportionate effect on women due to our habit of living longer. It's something like 75% of EU national women over the age of 70. EU nationals over the age of 75 are women. In the UK. Yeah.
Where the risk is that there will be a lot of vigilance in the media, in politics, and so on, and the government is aware of that and actually under some pressure, therefore, to not fall over. That's a good thing. Whether that vigilance is sustained as long as it needs to be, because this will not be as much of a problem next Easter after Brexit when everyone's watching for it. It will then be a problem in the summer and autumn of 2021. And if it becomes a very big problem, it might happen in the summer and autumn of 2026. And that's because people maybe who got onto pre-settled status when they should have got on settled status and didn't have it. And whether or not we have the mechanisms to do that. Now, it might be if you've said, people who are eligible, we've actually got a policy of saying if you're eligible, we're quite keen to grant it to you. In the end, that will be fine. But these are different. So it's the sustainedness of it. But the positive side to that is that inventing this scheme is exactly what did not happen in 1971 and 1973. That you created a big change in the law, changed people's status, and you found out when they retired 40 years later and they ended up in another system. So that's why this spring all of the message should be in the advice, the communication, the support you need to apply, and then some real vigilance about that people don't get mistreated in it, because we are deciding the scale of the problem 2 years later, 3 years later, and 6 years later in how much we invest in the reach of the system now. But I think there's a very big chance that a lot of people will be on pre-settled status who aren't meant to be, and that nobody will be looking out for them 5 years down the road.
But I've got a concern that there'll still be problems years down the line. So, parents who didn't register their children under the scheme because they wrongly thought their children were British. Some elderly EU citizens that even now are saying, why should I get engaged with any of this? I've got a passport, I'm allowed to be I've been here for 45 years, I'm not going to do this. And then, when they come to the point in their life where there needs to be a check because, they're accessing education or their healthcare or reassessment of social assessments, then at that point, it's going to be like, well, where's your settled status? I didn't need one. I thought I never needed one, or I didn't apply for it because I didn't really need it. And that's the problem. Later on down the line, there's going to be obstacles for people if they haven't engaged with this.
Back to Caroline Russell.
Yes, looking at the impact of all these changes on community cohesion, and Last year, Sunder, you came to our open mic session and raised a lot of concerns about EU exit, about the sort of heightened feeling of them and us in UK society. And just wondering if you think that that has happened, if you think that's getting worse or more evident, and if so, what is it that you're looking at to provide evidence of that?
It's hard to gauge and give a definitive answer of it. I would say that the politics of issues like Brexit are now perhaps more polarised at the end of 2018 than they were at, say, the end of 2016, and at both ends of the debate, and that has some dangers, and that in either, I would say, a no-deal scenario, or possibly in a scenario where there was a referendum and some people didn't think it should be happening at all, you know, you might see a more heightened polarisation, you know, in the new year, next spring, in the summer, during these political events, where just that heightened atmosphere and how that feels on social media, you know, might affect people in their lives and how they feel. So while those are all legitimate political debates, I think we should be looking for ways for people of different political views, different views of Brexit, to try and get some foundations in place about behaviour, you know, hate crime type issues. I think we've lost that to a surprising extent. Although we've lost the consensus of whether you're left wing or right wing, Remain or Brexit. You know, obviously hate crime and xenophobia are bad, and we had something which is that people on all the political advocates on all sides thought all the EU nationals should be allowed to stay, but we didn't make a quick decision, and so people felt very worried about that and felt very bad about that. And we have in principle, you know, whatever side you are of Brexit or politics, racism and hatred and chat on the street is bad. But what we've lost is we've now got a political polarisation, for example, about whether that's happening or not, or whether Liberal people have made up that that's happening because they don't like the referendum, and therefore other people would say, well, I'd be against it if it was happening. I think you've made it up and you're just trying to put all of that in the Guardian. So we've actually got a job, you know, hate crime can't be a 48 versus 52% issue, it should be a 90% issue. We've actually got some work to do to separate out, you know, I didn't like your campaign, you lied on a bus, you know, why don't you lot accept the result just because you lost? Separate out that stuff from but do we have shared norms and agreed norms about if people get shouted at in the street? Because if you get that heightened, it's not that most Leave voters think it or anything, but the 5% of people who do think it do start saying, why are you still here? Why are you still in my country? I want a no deal now. And actually we'll be quite confused in the sense of you're having a no deal Brexit, that everybody's got 2.5 years to allow to stay and that you've got free movement. Yeah, that is a surprising thing, whichever side you are. So we've lost something really important, which is just foundational norms against prejudice and hate crime to the polarised politics, and that you've got to keep, I think, that out of communities and try and get that back. And I think Remain and Leave voices deliberately being seen to do that together while having quite big arguments about everything would be quite important.
I think that requires the leadership to do that. I mean, Theresa May's comment on queue jumpers just didn't go down well at all, because, you know, no one's abusing the system, no one is queue jumping, no one is taking advantage. They're EU citizens who have a right and exercise that right to come and choose to live in the UK, and then to paint EU citizens under that brush. And there are neighbours, our teachers, our nurses, our hairdressers, and our friends, family, lovers. To paint them under that brush is completely wrong. And that's where the rhetoric is coming from. If the leadership tells the general public this is how it should be, that's the message we send.
And isn't there a sense not just about the messaging, because I could even go back further, thinking actually this was a settled issue until the words were said at Chequers in shorthand, which took us back a step, even though I thought there was lots of grey areas that I think you outlined earlier on in sort of your presentations. But so it is the issue that the message in this particular time, even with the polarisation where we are, politicians just watch your language.
Yes.
Because you can create more problems, either for more anxiety within EU nationals, or create more problems with those in building up whatever sense of resentment that they feel that there is, or why they voted or feel cheated around that. And is there a case then that actually, I think that's probably the wrong word, but honesty with politicians and where we are, because it's quite interesting. There will be a number of people that will feel that this does not represent what they thought was going to happen to EU nationals, which has been very clear in the media. Being a politician's and messaging that goes out, you think it's very clear. When you talk to people on the doorstep, it's not very clear about what they think your position is or where, about what the reality is and why it's beneficial to this country. Because even though this opens up a whole number of issues, the case that those citizens, EU citizens, have made a contribution, let's be honest here, I think there's a moral issue why they should stay, but there's also a very good business case, a UK business case, of why we're talking about settled status for those here and a different sort of status for people coming in. And that's where I think the honesty isn't coming across with politicians. I don't think we hear enough about that in this debate, about what those issues and why they've come to these conclusions. So it will become dressed up as, this is the EU holding something over us, when actually the reality is of the negotiators on the UK part have realised actually this is where we should be. With all sorts of dressing it up and the spins that go on about political stances, about controlling borders. Have I got that wrong? Have I missing something? I'm a practicing politician, or
I think part of the problem goes to the fact that there is a sort of a policy cognitive dissonance here in terms of how we're dressing up future free movement. We're saying we're ending it, and therefore justifying it by describing free movement as a problem or a blight, which reflects upon the people who've already exercised free movement. And there needs to be a sort of a greater transparency over that dissonance. So over saying, look, this is what we're doing over future free movement, because that's what's being translated, what's being interpreted as the impetus behind the referendum. But we are embracing those people who had, prior to the referendum, prior to Brexit, prior to the end of the transition period, exercised those free movement rights, and celebrating what they have contributed, and will continue to contribute, yes, and justifying it on that basis. And I think you're quite right that the problem of rhetoric goes back, quite some way, in that prior to the referendum there was a very strong anti-free movement discourse charging the Leave campaign, and there wasn't a counter-narrative from the Remain campaign which focused very much on the overall macroeconomic benefits. If you looked at the Stronger In website, there was a whole list of benefits of being in the EU, and free movement of people was not on that top 10 list. And so there was no attempt to engage with that or address it head on. And I think that was problematic, because there was an opportunity, regardless of what the actual outcome of the referendum was, there was an opportunity to try and command that narrative a bit more and make it more positive and make it warmer and more welcoming, and recognising very much the human dimension and tapping into the fact that an awful lot of people, however they voted, do like and get on with their neighbours and their colleagues and don't want them to be booted out.
But that's why that distinction between the past and the future, that does need to be reciprocated, and both sides of politics, both sides of the referendum debate have to agree to do that, and that's been difficult. I commissioned a poll the weekend after the referendum, published it a week later, and it's 84% for EU nationals staying, so it's 90% of Remain voters, 75% leaves, and a lot of people were very surprised by that, and to some extent it was the sort of, the Remain liberal kind of newspapers that were as surprised by it as well. So that was there because there was a principle there, which is that you can have your view about opposition to the European Union, so you had a referendum, you can have a view about policies we might introduce, but you don't change people's lives now. So that's why the queue jumpers language is wrong, and it's important to apologise. But it's also important then for the Liberal side to say, well, we like free movement, we think it's a mistake to end it. They need to take the deal on. But they also need to take the deal on separating the past. It's actually a legitimate political political position to say I want to leave the European Union, change the free movement rules, and I can treat people well. You can't then say you're an absolute hypocrite because you can't do both those things. Because of course you can, as a principle of human justice, say we don't change things retrospectively and that future changes are for future people. You've got to take that deal if you want to say, look, we want to have a fight about the future immigration policy because we'd still like it for business reasons and so on, but we accept. So that's where I think we need the foundations. There's a positive thing here. I think there are worries about hate crime. There's evidence about hate crime, and I'm sure hate crime is still underreported. And there's polarisation around Brexit and politics generally. There has been a big reduction in the heat and temperature of the immigration debate. The salience has fallen a lot and attitudes have warmed up a fair bit. And, it's counterintuitive, but it has happened. If people ask the people who change their minds, why have you changed their minds? Actually, there are two different reasons of relatively equal weight. If you were a sort of person who ended up voting Remain in the end, but you didn't like free movement that much, you're now warmer to it. You've seen stories of the 3 million, you're more empathetic, you actually regret it, Windrush has happened, the newspaper stories have been positive. If you're a leaver who did want to end free movement and still wants to, you feel a bit more powerful, you feel a bit of control, and you're expecting some changes. And so for two different reasons, there's been a reduction in the temperature. So we've actually got more temperature about Brexit and Europe, but we've got less temperature about immigration, and we should, by being very vigilant about hate crime, we should welcome that, because actually the public, when they go, okay, a new system, what do you think should be in it? It's actually a moderating discussion, because they say, well, actually, skills are good and care workers are important. And that people at all different levels of the debate end up thinking, well, I want a control system, I've got to think quite hard about it. So in a way, having an open immigration debate about the choices we want, should we keep free movement, should we control it differently, should we change it, is actually quite moderating, because it's not just a sort of, is it all good or bad? But that has happened, and we should lean into it and therefore have more confidence to have the kind of leadership you were discussing.
I think the positives on immigration has never been talked about in politics. Never. I mean, this goes back generations.
A long way.
Yeah, a long way. And this is why we're here where we are with the hostile environment and some of these attitudes. And I'm not a politician. I've never worked in politics, but I worked in immigration law my whole career. And so I've understood and seen examples of the hostility that are around there for non-EU citizens. And so when the referendum debate started hitting immigration, that's when, and I started listening to the debates on immigration, and there was no positive message on immigration at that point. That's when my fears started really hitting home, that there's a massive risk that the vote could be leave at that point. Because from my own personal interaction with this, I understood that there is a real undercurrent of hostility towards migrants. Not on a massive scale, but it's out there. And I understood that if you tap that enough, then you may have, the risk of leaving was then increased at that point. And I can only talk from my interactions with EU citizens now. There is that hostility. I've listened to examples of some EU citizens talking in their own language, in German on the bus, and then someone walks up to them and said, "Look, why are you speaking that language? We're voted out. Why are you still here?" I spoke to some woman who set up her own branding business. She's been here for 15 years. Then her friends and colleagues start talking about migration and how we're, glad we're voted out, now we can kick all these people out. And then she'll turn around to them and say, well, you're talking about me as well, and they didn't realise that, she's Belgian and she's been here all these years, but she's got no accent, you can't tell, but she's turning around saying, I'm one of the people you're talking about. Do you want to get rid of me? And they're like, no, we don't want to get rid of you. We're not talking about you at all. There are hate crimes, and there has been instances of violence. We don't know how widespread, because I think they are really substantially underreported. But the embassies do receive examples of where people have been threatened violence or verbal abuse because of the hostilities now that they're facing, that non-EU citizens have faced for a long time, because there's no political strength out there to say, this is, we're an open country, we welcome migration, these have been net gains for migration, this is why we want people here, this is why we want people to stay, and to counteract all of the hostile messages.
I think it's incredibly important to counteract, the prejudice and hate crime. I just want to challenge or disagree a bit on just one point. So, I mean, it is often said now by the more liberal and the more Remain end, the other side made the negative case, we didn't make the positive case. It is absolutely not the general public perception, say, of most Londoners or most people, that the positive case was not made. So some people feel the positive case was not made and it was a mistake, we shouldn't do it. a lot of other people feel that some people, and they mean big business, but they also mean Tony Blair and David Cameron, Nick Clegg and George Osborne, have been making the positive case on the GDP gains and kind of blanketing out at us and therefore not listening about the local pressures, and that's all they were doing and they weren't listening. So there were two very polarised perceptions that we weren't allowed to say we've got some problems with it, even though we've got some problems with it, but we're not nasty to our neighbours, and so on. So there are some people who feel that the positive case was blasted at them and they weren't allowed to say anything else about it. And there are other people who feel you think you weren't allowed to talk about immigration, but you've been shouting about it for 40 years. So you obviously were allowed to shout. So there is a real polarisation where people actually feel relieved after Brexit. The debate has opened up. We should have done it much earlier. We should have been dealing with it. It's good now. And other people are saying, well, you've obviously talked about we need to close it down. And I think it's worth recognising that polarisation and getting into the discomfort a bit of saying, well, let's have a discussion where all of those views are legitimate. There's then quite a lot of common ground, actually, about immigration and especially integration between people who felt they weren't allowed to talk about it for 15 years and people who feel, can't we talk about something else now? So in a way, the Liberal group has to not say, well, I just want to give you the facts about how good it is, or can't we talk about something else? They need to actually say, let's talk about your pressures, let's talk about my gains, and let's put together a policy. So the London is open message, for example, which is very important. It should work very well. It needs to work for the 40% of Londoners who will leave. They need to say, yes, London's open. I voted leave, but London's open, rather than also being very valuable to the 60% who voted Remain. I'm really pleased London's saying we're open because everywhere else isn't now. It's got to bridge that divide.
Sorry to continue because I interrupted.
No, don't worry. London is open is exactly what I was about to ask about, which is, do you think that the Mayor is doing enough about the need for London to remain an open and tolerant place to live and work? And I think, Sunder, what you were just saying about the fact that it's got to work for people who voted leave as well as for people who voted Remain, do you think that that's coming across enough from the messaging that's coming out from City Hall?
I don't know if it is or it isn't, but I think it would be worth finding out about that, because if it's really working, people feel very open, it isn't. Broadly, I think open versus closed is not a good way to make the case for open. You're actually saying something quite pejorative about the other group, and that, you know, some people are open versus closed, some people are shut the borders, it's quite rare, and most people are like, London is open, but how do we manage it fairly for everybody? And a certain type of open versus closed is very important to say it to the EU nationals themselves. It's very important for London to say it to the other cities, etc. But what it can't be saying is London doesn't really agree with the rest of the country. It's partly true, and that therefore the people who voted leave in London aren't as London as the rest of us. It should be saying, actually, you know, whatever these big national debates happen about Brexit, London's still going to be London. We all agree with that, and the openness and getting this right, and that, you know, I think, you know, testing that in the boroughs that voted leave, but with the leave voters who are in all the Remain boroughs as well, and not to concede too much so that the Remain voters don't feel they're part of it. I think that's quite an important part of the London is open story.
Thank you.
Are there any more questions? I think we've exhausted our core questions. Is there anything you think we've not asked you that you think we should be aware of? Is there something, oh shocker, they've not said anything about this, but you want to tell us? We're going to reflect on what you've said to us, and we'll come back to you with any follow-up questions.
Well, the bit we didn't really do, but I mean, you know, there's so much to do. I mean, there'll be a white paper next week if they can decide on it. And it's important for people to realise these are the 2021 changes, not the next March changes. And there's going to be a debate about that, and it will be about the low and medium skill matters debate. But it's worth, instead of saying why have the debate about skills at all, I think it's a good chance to let's take the consensus on high skills. Student and skilled migration across the political consensus, across the referendum, there's a consensus on that. Now, managing low and semi-skilled well in work so that it works for London, it works for everybody, that's harder work. Let's talk about that as well. But there's actually a good thing there's a good thing, even if you want migration all the way up and down the skills level, there's a good thing in realising that actually there's a consensus on student migration, skilled migration, and therefore saying let's not talk about skills at all because it's good or bad migrants is slightly missing part of the point, that actually if you take the skilled migration, you can't have the net migration target we've got. And then we do need, obviously, mid-skilled migration, low-skilled migration, care homes are important, but that not just going straight to, in a way, a kind of take everybody versus it's all closed is quite a subtle thing to get right, I think, in this next debate, which will be this white paper this week and the Brexit crisis, but then there'll be an immigration bill next year, which is probably the most important piece of immigration legislation since the 1971 Act. And if that is a controlled system, how can a controlled system let London be open? That's really hard work, I think, for the next period.
I just wanted to add a quick thing. We touched on social security coordination before, and I have some concerns about how the future system is going to work. I mean, particularly if there is no deal and there is no sort of ring fencing of citizens' rights that includes social security coordination, then we could see a significant problem, as Chris was saying before, in terms of the aggregation of pension contributions working smoothly, if people make pension contributions in different member states, and then having the ability to export their pension and to have that uprated, etc. Even in the event of a deal that includes provisions on social security coordination, my concern is it's mainly from an administrative point of view, that my experience of working in the system now is that it's kind of mal-coordinated coordination. It's really quite hard to get things to work appropriately the way they're in theory meant to, even with specialist support, even as a member of the EU. An example case that I had involved what should have been a fairly straightforward exportation, very temporary exportation of benefit claim, and I went on to the relevant benefit office website and was directed to contact the exportability team, and we did, and the exportability team did not exist. Then I phoned the number that I was told to phone, and someone answered the phone and said, "Oh, sorry, I don't think this team exists. Have you tried ringing this number?" And it was the number I just phoned. It was like being lost down some sort of strange administrative rabbit hole. And that, as I say, is in the position of being a member of the EU, where we're supposed to be coordinating social security smoothly, and it's anything but smooth. My concern is that when we're not a member of the EU, it's not going to get any easier. And for a number of people, particularly on aggregation of contributions or for small periods of exportation, for all sorts of sometimes quite dramatic life reasons. You know, if someone has settled status, but they need to go to another member state to look after an elderly relative who's dying temporarily, and during that period need to export a benefit, I think it's going to get harder, and I'm worried about that.
I think accessing social assistance for those on pre-settled status is going to be a problem as well. Because pre-settled status won't gain you social assistance. They're still going to, this DWP is still going to ask you whether you're working, whether you're self-employed, and so on. So you still, you know, settled status will be the gateway to social assistance, but pre-settled status should also be as well. If the test is residence and identity and so on, then once you get pre-settled status, it should be the gateway to social assistance as well, and that's going to be an issue. I would also say, and this is going to be more relevant as we get closer to March, if we have a deal and the political messages were ending free movement, I think maybe the message needs to be much more clearer than that, because the message saying ending free movement gives to some in the public who don't understand this, that they'll think that free movement ends in March for EU citizens, and it doesn't, it continues. And so that message needs to change as well.
Yeah.
One final point I would make about integration and citizenship, you mentioned the voting rights, the way we look people. We don't know where we're going to be on the voting rights. But also, you know, to have 1 million people in London, 3.5, 4 million people who are here, they're told they're permanent parts of our community and they're not citizens. We should be thinking, I think, about, which just hasn't come up in the public debate, so many other complicated things, there should be an easy route for citizenship to these people, and the government ought to be encouraging it. Because, I mean, it'd be good if people do get the right to vote in local elections and London elections, but actually if you're permanently here, that's what settled status is. I still think there should be an opportunity to say, shouldn't there be a sort of route that if 4 million people are going to go through a system, why have we not asked people, have you thought about being a citizen, and cut out the barriers and loopholes and the costs for this group. I think that would make the biggest difference to integration as to whether, because it's the largest ever, you know, in a way, population of people without citizen rights who are here permanently.
Can I thank you for the way that you've answered our questions and raised some very important points for us to consider, and also for the Mayor to consider it consider both on his own actions, but also actions we're going to ask of others. So thank you for that. Formally, I need to say, can we note the report before us and the discussion that we've had? Delegate authority to me as chair in consultation with party group members to agree the outputs of this discussion and previous discussions. Thank you. Can I just then go back to formal business? Date of the next meeting is the 13th of February 2019 at 2 p.m. But I suspect we might need a special meeting depending on where we are, and I will work with the Secretariat to try and identify that date so we can try and think if we need something, we have something ready. We'll have a look at that. Item 7, there being no any other urgent business, I now declare this meeting closed. Thank you very much.
Thank you.